Welcome to this next brilliant, entertaining and satirical vlog exposing the dystopian nightmare of our family court system. Please be in no doubt that this is a satire, defined as the use of humour, irony and exaggeration to expose and criticise the all too often sick in the head family court lawyers and the broken family court system. In this vlog called I Can Help You to Alienate Your Children from Your Ex or Your Money Back, I'm going to expose exactly what I see these family court lawyers do on an industrial scale to easily manipulate the family court and judges from planet stupid to deny direct child contact with the non-resident parent, who are mostly fathers, for over 12 months. Where during that time the resident parent, who are mostly mothers, can alienate the children, making them fearful, aligned and attached, ensuring that they never want to see their dad again. And I am so confident that I could help to achieve that if I was like a sick in the head family lawyer, that I would even offer a money back guarantee. But before I spill the beans, I simply must run my excellent introduction. I am Philip Kedge, a retired police chief inspector, the director of the amazing McKenzie Friend UK network and fearless family court vlogger. In all of my vlogs, my views and opinions are, of course, entirely my own. Now, for all of your family court needs, please visit our one-stop shop at www.contactphil.co.uk. Now let me make this perfectly clear. We know that in 20% of family court cases there are no allegations of domestic abuse, and from what I observe, in another 20% of cases there is of course abhorrent domestic abuse where children and adults need safeguarding. But in this vlog, I am referring to the 60% of cases which I called out as being nothing more than mudslinging bollocks. Yes, of course, there may have been unsavoury matters in a relationship that deserve an apology. I'm not condoning it, but these incidents should never be a matter for the family court, and I say are being mismanaged by judges from Planet Stupid on an industrial scale. With that in mind, let's make a start, and as we go along I am going to put these scores on the doors in relation to the months that we can manipulate the family court to deny contact with your ex. Let's set the timer to 0. Firstly, as soon as possible after separation you must stop contact between your ex and your children. If you don't, then making spurious allegations of domestic abuse and coercive control against your ex lacks credibility. A position of I'm a victim of domestic abuse and need to protect the children, but I have allowed contact doesn't really wash. You have to stop contact. Now, after stopping contact, string your ex along with the mediation carrot and stick for as long as possible. But make sure that when the time comes, you turn it down with the exemption of stating domestic abuse and coercive control. Fathers are typically so slow to react, they are like rabbits caught in their headlights, and you should aim to buy yourself at least 3 months of no contact before they even consider an application. It is very rare for a father who is confused, disorientated and disempowered to make a decision to apply to the family court within 3 months of separation. So, let's put that first score on the door. That is 3 months of no contact before your ex even thinks about starting a court application. It's the perfect start on our path to alienation. So your ex has finally got round to filing a C100 application to the family court. But don't worry about that, because it will take at least 6 to 8 weeks, if not longer, given the clogged up family court before a first hearing date is set. In the meantime, we will work hard together to produce a list of spurious allegations of abuse and coercive control digging up every little bit of undesirable behaviour that may have occurred throughout the entire relationship. For example, every time they may have raised their voice in anger, every time they showed toxic masculinity, every time there was an argument where you felt threatened and intimidated, perhaps there was once a minor physical scuffle between you. That would be brilliant, because that's domestic violence. It doesn't even matter if you started it, because the court is going to have very little interest in your behaviour as the resident parent. The spotlight is going to be entirely on him. So, on receiving a copy of the C100 application submitted by your ex, we are going to respond by submitting your C1A, telling the court how horrible he is and what a victim of abuse and coercive control you are. You are going to list 8 to 10 incidents in very general and non-specific terms and make statements such as the entire relationship was categorised by coercive control. That will settle the Kafkas and family court alarm bells ringing, the family court bus is already being revved up, and all we have to do is to throw your ex under it. So, the next thing that is going to happen is the Kafkas safeguarding phone call. But we are going to make sure that you are prepared for that. All you need to do is to explain that you are a victim of domestic abuse and coercive control, and that you stopped contact as you don't believe that the children are safe with him. And don't worry if your ex is going to deny the allegations. That means that he is in denial and therefore a greater risk to you and your beloved children. Now, here comes the silver bullet. When the Kafkas family court advisor writes their safeguarding letter to the court, you want them to say something like this. The mother has stopped contact, citing serious allegations of abuse and coercive control. These are denied by the father. The mother should be asked to provide a statement of her allegations, and the court to then apply Practice Directions 12J to determine whether a fact-finding is necessary. Until then, I cannot recommend direct contact, as I am unable to determine that it would be safe. With that statement, all your prayers have been answered. For your ex, the father, that is the safeguarding letter of doom. They are now in a whole world of pain, and there is very little that they can do about it. You are now skipping down the yellow brick road to parental alienation, and I'm right there by your side. So, the next stop is the first hearing dispute resolution appointment. Let's take a pause here to check the score on the door. It has been 2 months from the father putting in his application to the first hearing. So the total time absent from seeing his children is now 5 months. How brilliant is that? Now, the first hearing dispute resolution appointment is going to be a breeze. The judge's hands are tied with the safeguarding letter of doom. You only need to continue to deny contact, and there is little the court or your ex can do about it. You simply support the Kafkas recommendation that you wish to produce a Scott schedule of full allegations supported by a witness statement. The judge agrees and makes an order that you have 3 weeks to file and submit your statement. Your ex has 3 weeks to respond, and we will then all rock back into court for a dispute resolution appointment. In the meantime, it is not safe for the father to have any direct contact with the children. But wait for it, the next hearing isn't going to be anytime soon. You can expect a minimum of 3 to 4 months. In that time, you can really get to work on the children, to mess with their little heads, to manipulate them against their father, and to make them fearful and even hate him. This is so much fun, And now you are going to appreciate how brilliant I am in my advice, which is of course similar to what I see the sick in the head family court lawyers give and practice on a routine basis. So over the next few months, statements are filed and served, and yours is brilliant, throwing as much mud as possible whilst telling your truth in the context that you recall. But what about the actual real truth? I hear the fathers cry. Well, let's not get bogged down in all that. It's the mother's truth and nothing but the mother's truth that counts. It's time to return to the score on the door. So it's been 3 months since the last hearing, which means that Dad has not had any contact with your children for 8 months. You have done brilliantly in protecting your children. They are starting to properly forget about their dad by now. They believe that he has abandoned them, that Dad doesn't love them anymore, that Dad has hurt you. And your children want to now physically, emotionally and psychologically align with you as their true protector. What an amazing mummy you are. So at the dispute resolution appointment, as you hide behind the green screen of victimhood, the judge from Planet Stupid reads your statement about how you have lived in fear, how you have had to tread on eggshells, and that you are now anxious and traumatised. It's plain sailing. The judge may strike out 1 or 2 of your allegations, like the one 10 years ago when at your wedding he spent more time talking to the bridesmaids. But other than that, it's off for a 2-day fact-finding hearing. Now your ex, whose mental health is now on the rocks, asks the judge for interim contact, but all you do is to remind the judge of the Kafka safeguarding letter of doom, which recommends no contact until the allegations have been resolved. And of course, they still haven't, so nothing has changed. The judge won't order contact, and it's off to a fact-finding hearing in, wait for it, 4 months' time. Let's put the score on the door. Yes, another 4 months. That makes a total of 12 months. 12 months of you being able to dismantle the loving bonds between father and children. 12 long months of suffering and heartbreak for your ex. All the missed birthdays, Christmas and other holidays. Him watching your son playing football for the school team. But best of all, my guarantee has been achieved. To help alienate your children for at least 1 year or your money back. I am quids in and it's high fives all around. Mum is over the moon and will be recommending my services to all of her divorcing victimhood friends. But let's not stop there. We are on a roll. When enough spurious mudslinging allegations are made, some will always stick. At the fact-finding, Dad is indeed labelled a domestic abuser and child abuser. It's not difficult. When raising your voice in anger, or walking in an angry manner, or throwing a soft, cuddly toy across the room 10 years ago, are all considered as domestic abuse, relevant to whether it is safe to see your children. Following the fact-finding, the judge decides to pass their judgment back to Kafkas to ask them to do a Section 7 report to assess the harm to the children and to recommend the next steps forward. That is fantastic, because guess what? A report takes 3 months to complete and you are unlikely to be back in court for another 4 months. You know what's coming next, folks? Yes, it's the score on the door. That's, wait for it, drum roll please, 16 months since your ex has had contact with your children. Happy days are here to stay, and the icing on the cake with the cherry on top is that your children are now so psychologically manipulated, controlled and traumatised that they don't want to see their dad ever again. It's time to put that bottle of champagne on ice. But of course it doesn't entirely end there. When Kafkas write their Section 7 report, it becomes clear that the main issue On the table is not that dad is a domestic abuser and child abuser, but more significantly, that it's been so long since the children have seen their father that they are totally detached, and forcing them to see him again is going to be an uphill challenge. Indeed, it may now not even be possible. The damage has been done, and total alienation has been achieved. How marvellous is that? I should have charged a bonus fee. Ladies and gentlemen, that's me done, and I conclude this satirical parody of the broken, inept, incompetent and incomprehensible family court system and the regular practices of the all too often sick in the head family court lawyers who generate conflict and hate for their own financial gain. It's all so very easy. If this vlog resonates with you, and I guess it will with thousands of you, then please contact me today at www.contactphil.co.uk. Until next time, stay strong.